Good day. Welcome to the channel. For our first episode, we will be discussing the case of Togado versus People. This is an En Banc case decided by the Supreme Court in the year 2024. This case talks about Republic Act number 101591, which punishes, among others, illegal possession of firearms and ammunitions. And in this case, the Supreme Court also discussed some matters that must be followed in these kinds of cases, particularly in maintaining the chain of custody. So let us go with the facts. So this case started when the Regional Trial Court of Santa Cruz, Laguna issued search warrant number 14-948 against the accused Benjamin Togado. So the court found probable cause that the crime of violation of RA 10591 has been committed and that there was good and sufficient reasons to believe that Togado had in his possession and control or custody unlicensed firearms and ammunitions. So the search warrant was issued and it was implemented by the police officers. And during the implementation, the police officers were able to recover a 45 caliber pistol and a magazine with 5 live ammunitions. One of the police officers, PO1 San Luis, then placed said seized items inside a Ziploc plastic and marked it with MMS-01-52914. After which, the search warrant team took photographs and prepared the inventory of the seized items. Thereafter, the team informed Togado of his rights as an accused and arrested him. The police officers were also able to secure a certification from the Firearms and Explosives Office of the Philippine National Police. This document certified that the accused Togado was not a registered firearm holder of any kind or caliber per verification. Thus, Togado here was subsequently charged with violation of Section 28 of Republic Act number 10591 or the Comprehensive Firearms and Ammunition Regulation Act for the crime or offense of illegal possession of firearms and ammunition. So trial ensued and the Regional Trial Court convicted Togado of the crime charge and the Court of Appeals affirmed the RTC. So after the Court of Appeals affirmed the decision, the accused elevated the case to the Supreme Court. So the issues in this case are the following. First, whether or not search warrant number 14-948 was valid. And second, whether or not Togado was guilty of violation of Republic Act number 10591. So let us discuss the issues. The first issue, and the validity of search warrant number 14-948. So here, the accused contended that said search warrant was invalid, it was void, according to him, because number one, there is nothing on record that would prove that the judge personally examined the complainant and the witnesses before issuing said search warrant. Number two, the accused contended that the address at Barangay Buenavista, Magdalena, Laguna, does not describe the place to be searched with sufficient particularity. So the court held that the search warrant number 14-948 was valid. The court even cited the case of Ogayon versus People, and they held that number one, failure to attach to the records the depositions of the complainant and their witnesses, and or the transcript of the judge's examination, though contrary to the rules, does not by itself nullify the warrant, because such requirement is merely a procedural rule and not a component of the right. Also, the court added that in the absence of records, a warrant may still be upheld if there is evidence in the records that the requisite examination was made and probable cause was based thereon. Thus, applying that in the case, the Supreme Court held that the search warrant itself stated the name of the applicant and that a witness was examined. In addition, one of the police officers, PO1 Alcantara, testified that before applying for the issuance of a search warrant, he inquired with the Firearms and Explosive Office on whether petitioner is a registered firearm holder. And then the other contention by the accused that the address does not describe the place to be searched with sufficient particularity, the Supreme Court held that the place to be searched and the items to be seized were described with sufficient particularity. The search warrant, according to the court, had a map attached to it, and it also enumerated the firearms to be confiscated. Thus, the court held that search warrant number 14-948 was valid. Now, let's go to the second issue on whether or not the accused was guilty of violation of Section 28 of Republic Act number 10591. So, ayan na. Spoiler alert, the accused was not guilty. But what's the reason why did the court held that the accused was not guilty in this case? First, let us study the elements of said offense. The elements of the violation of Section 28 are as follows. Number one, the existence of the subject firearm. And number two, the fact that the accused who possessed or owned the same does not have the corresponding license for it. According to the Supreme Court, the prosecution failed to prove the first element. The court held that the first element was not proven because of the prosecution's failure to show that the integrity of the firearm was preserved. RA 10591 does not contain any provision on chain of custody and the proper handling of seized firearms and ammunition. However, according to the court, it should be stressed that the PNP has an operations manual to guide its members on various matters, including the handling and preservation of the integrity of the confiscated firearms. At the very least, according to the court, the police officers should have followed its internal operations manual. Although in this case, the facts or the events in this case happened when the 2013 PNP manual was in effect, but right now we have the 2021 revised PNP operational procedures manual already. Nevertheless, the Supreme Court emphasized that for confiscated firearms and ammunition, it is more prudent to place the marking on the confiscated item itself, not on the plastic. Remember a while ago, what was marked by the seizing officers was the plastic where the seized items were placed. Hindi dapat. Dapat doon sa ammunition, doon sa magazine, or doon sa firearm yung marking. To continue, according to the Supreme Court, law enforcers and courts should remember that the crucial piece of evidence is the confiscated item, not the plastic containing it. Once the confiscated item is marked and placed inside the plastic container, the container should also be sealed in a manner that would indicate whether the plastic has been tampered with. In this case, PO1 San Luis admitted that he did not indicate any marking on the gun itself, its magazine, and the live ammunition, but only on the Ziploc plastic where the gun was placed. PO1 Alcantara corroborated the testimony of PO1 San Luis that what was only marked was the plastic container and not the gun. PO1 Alcantara also testified that PO1 San Luis marked the plastic with MMS-01 and the date 5/29/14. Not only did the evidence produced in court bore different marking, but also it appears that the gun and the magazine itself bore the marking, not the plastic. So here, the marking itself and the facts on where the marking was placed were actually inconsistent. The testimony did not conform with the actual marking found on the evidence presented in court. Also, according to the court, the accused highlighted PO1 San Luis' admission that when he retrieved the firearm from the evidence custodian, the plastic marked MMS 0152914 was already destroyed. Thus, when the firearm was presented in court, it was in a different container, and PO1 San Luis could not ascertain whether it was the very same firearm confiscated from the accused. Thus, the court held that the discrepancy in the markings, the tampering of the plastic bag, and PO1 San Luis's admission in court led them to conclude that there exists reasonable doubt as to the guilt of the petitioner. The court also discussed that one of the leading cases in firearms, the case of Olarte, is actually inapplicable in this case due to difference in set of facts. The court explained that the police officers in Olarte were able to identify the confiscated item and were also able to explain why the marking placed on the hand grenade differed from the marking in the examination report. So there was an explanation. Unlike in Olarte, the police officer in this case, PO1 San Luis, could not testify with certainty whether the firearm presented in court was the same firearm confiscated from the accused. He also could not explain why the container presented in court bore the markings MAG MPS, when the records of this case indicate that the marking placed upon confiscation of the firearm was MMS-01-52914. So malayo, ibang-iba talaga. Worse, there was an admission that the container bearing the mark MMS-01-52914 was destroyed. So in essence, the integrity of the seized item was not preserved. Jurisprudence dictates, according to the court, that the corpus delicti in illegal possession of firearms is the lack of license to own or possess a firearm. The Supreme Court explained that for them to rule in this case that there is no need to present the firearm as evidence would have a dangerous consequence. It would be easy for anyone to plant a firearm as evidence, arrest the person, then charge them for illegal possession if their name does not appear in the database of the FEO of the PNP. Anyone could easily be convicted by the mere issuance of a certification that they do not have a license to own and possess a firearm. Thus, according to the court, the preservation of the integrity of the confiscated firearm is crucial in proving the corpus delicti, improving the first element of illegal possession of firearms. The Supreme Court added that another reason why the firearm should be presented in court is its effect on the imposable penalty for violation of RA number 10591, because the penalty depends on the kind of firearms confiscated from the accused. So as we've mentioned a while ago, the accused here was acquitted. So in acquitting the accused, the court have discussed that there was reasonable doubt because the prosecution was unable to prove that the firearm presented in court was the same or exact same firearm confiscated from the accused. However, the court recognized that in previous cases, they pronounced that the firearm itself need not be presented as evidence, for it may be established by testimony. To avoid any iota of doubt and to protect an accused's constitutional right to be presumed innocent, it is imperative that the exact same firearm recovered from the accused be presented in court. The non-presentation of firearms should be the exception rather than the rule. So again, as held in this case, the general rule is present the firearm. Prove to the court that the said firearm being presented in court was the same firearm confiscated from the accused. That is the general rule. And what is the exception? It is the non-presentation of the firearms, although there must be a testimony to that effect to establish the identity of the firearm. But again, that is just an exception. And finally, the court laid the following guidelines okay, that must be followed in relation to this offense. Let us read the guidelines. Number one, where an accused is charged with violation of RA 10591, the presentation of the exact same firearm is required for the court to determine whether the accused should be convicted, and if so convicted, the proper penalty to be imposed. Number two, when a firearm is used in the commission of a crime which prescribes a lesser penalty, Section 29 of RA 10591 states that the penalty imposable shall be the penalty prescribed for illegal possession of firearms. In this situation, the use of a firearm is a qualifying circumstance, and the penalty imposable depends on the classification of the firearm. Thus, the presentation of the exact same firearm is also required. The rule remains that qualifying circumstances must be proven with the same quantum of evidence as the crime itself. Number three, when the use of a firearm is an aggravating circumstance or is inherent in or absorbed by the nature of the crime charge, the presentation of the exact same firearm is preferred. But the presentation of secondary evidence may be considered by the courts. Number four, in all situations where a firearm is confiscated or recovered from an accused, the confiscated firearm must be marked, photographed, and duly authenticated and its integrity preserved. The failure to comply with the foregoing requirements should not, however, automatically result in an acquittal, but may constitute reasonable doubt as to the guilt of the accused if not sufficiently justified. Okay? So those are the guidelines set forth by the Supreme Court in this case of Togado versus People. Thank you for listening, and I hope you learned something from this case.